All right, welcome to today's lecture, which is going to be about judicial federalism. Judicial federalism is broadly understood to be the idea that the federal power could be expanded over the states through the court system. And really specifically, what we mean when we say that is by the Supreme Court. When I mean the Supreme Court in this case, I'm going to be talking mostly about the Marshall Court. John Marshall, who you see on the screen right there, was the Chief Justice during a really important period of the court's history. The Supreme Court is always named after the Chief Justice, so that's why I call it the Marshall Court, because he was the justice at the time. Today, the Chief Justice of the Supreme Court is John Roberts, which is why we call it the Roberts Court. So let's go over a couple of key concepts and terms. The first is judicial federalism. Obviously, judicial federalism is nothing more than the balance of power and authority between the state courts and the federal judiciary. But in this specific context, we're talking about the expansion of federal power at the expense of the states. Now, we also need to talk about the Supremacy Clause. The Supremacy Clause is Article 6 of the Constitution, and it clearly says that federal law is, quote, the supreme law of the land, end quote. What that means is that if state and federal law conflict, the federal law usually prevails. And this is the foundation of federal judicial authority over the states. And this is predominantly what John Marshall is going to use to expand federal power increasingly over the states. But it's not going to resolve all the issues. The United States has what's called a dual court system, which means if you get sued, odds are you're going to be in state court because that's where most of the sausage gets made. However, you could end up in federal court. There's two district courts on both sides. There's appellate courts, and then usually in each state there's a court of last appeal, and sometimes that's called the Supreme Court, sometimes it's not. Doesn't particularly matter. Now, the difference here is that if a case involves a constitutional principle, it is supposed to go in the federal courts. And so that is what is going to allow Marshall the ability to really expand that federal power. But he's not going to talk about everything. Critically, he's not going to address slavery. He's not going to address westward expansion in a lot of ways. Not going to address education. He's not really going to address a lot of social issues. Those are all unresolved tensions that we're going to have to wait until the middle of the 19th or even middle of the 20th century to see ended. Now, the most important case that you need to know is Marbury versus Madison. If you don't know any cases after today, you should understand this pivotal case. So in the last days of his presidency, John Adams appointed several what we call midnight judges. These are judges who were appointed essentially at the last minute after his party, the Federalists, had lost power to Jefferson and the Democratic Republicans. Now, one of these guys was named William Marbury. He was supposed to get a job as the Justice of the Peace. And his commission, it was signed and it was sealed, but it wasn't delivered until Thomas Jefferson took office. Jefferson's Secretary of State, a guy by the name of James Madison, who's going to go on to do his own successful presidency, refused to deliver Marbury's commission. And so Marbury turned around and he sued. And the petition got all the way up to the Supreme Court. And he was basically asking Adams to return the commission, relying on the Judiciary Act of 1789, which was passed right before the Federalists lost power. Now, in his decision, Justice John Marshall ruled that Marbury was right, but he still lost. He was right that he could get his commission, but he was wrong because the Judiciary Act that I just mentioned, the one of 1789, he decided that that was unconstitutional, so the writ was no good in the first place. Okay, none of that matters. I'm going to be honest with you. Absolutely none of it matters. If you don't understand why poor Mr. Marbury didn't get his job, doesn't really care, okay? Because all that matters is in the decision, Marshall establishes a concept, and that concept is called judicial review. It's the most important concept in American jurisprudence. It is the idea that the Supreme Court of the United States gets the final say on whether or not something is constitutional. If it is, it can stand. If it's not, it's got to go away because nothing is allowed to conflict with the Constitution. States, the federal legislative branch, no one can pass a law that conflicts with the Constitution. Now, I want to point out, this is not stated anywhere in the Constitution. It's not like it says, oh, and by the way, the Supreme Court has this authority. No, Marshall created it out of thin air. So the Supreme Court is really our only branch that legislated for itself what its own powers were. But judicial review is what gives the Supreme Court the ability to do all the things that today it still does. And we see that coming into play pretty quickly in a case called Gibbons versus Ogden. The background to this is kind of silly. So, the state of New York granted Aaron Ogden a monopoly to operate a passenger steamboat between New York and New Jersey. So, he was the only one, according to New York State, that could ferry passengers back and forth between these two states. But Thomas Gibbons, who held a federal license to run steamboats in interstate waters, started to compete with Ogden anyway, and Ogden sued him to stop him. And so the question was whether or not this was legal, whether or not New York could effectively regulate interstate commerce by granting monopolies. And in a really important case, Justice John Marshall ruled no, New York can't, because the federal government is the only government, not states, not local governments, that has the power over interstate commerce. So if a good is going to move from one state to another, states aren't allowed to erect their own tariffs or their own prohibition on goods. The federal government controls all of those things. And the rationale is pretty obvious on this one. You want commerce to thrive. And for commerce to thrive, it needs to be easy. And for things to be easy, you need to not have states erecting their own impediments to trade. And so it was an important decision because it encouraged the expansion of business over state boundaries. Critically, Marshall also broadly defined commerce, and we've been expanding that definition ever since, in this case to include navigation. And it was another way in which the federal control was expanded over the states. Next, we'll look at Chisholm v. Georgia. So, Alexander Chisholm was the executor of a South Carolina estate, and he sued the state of Georgia in the U.S. Supreme Court to collect payments for goods that he said he alleged during the Revolutionary War. So, essentially, what he was doing was he believed that South Carolina had the right to sue Georgia for something. Georgia argued it was a sovereign state, and you can't sue a sovereign state without its consent. This concept is murky, but it's called sovereign immunity. So essentially, you have an individual citizen here trying to sue a state, and the issue is whether or not that's legal. Can a private citizen sue a state? And again, in an expansion of federal power and the power of the people, the Marshall Court ruled 4-1 this time, it wasn't unanimous, that the states could in fact be sued in federal court by citizens of another state. Now, this decision was very controversial, and states feared that they were going to lose their own sovereignty. And so, in response, the Congress and the states quickly ratified the 11th Amendment in 1795, which barred such lawsuits without a state's consent. Now, states quickly consented to this, but it's a pretty interesting example of the way in which the Constitution continued to grow and develop throughout the early American Republic. People, when they wrote the Constitution, because it was so short, didn't necessarily know how it was going to apply in all cases. And they certainly weren't ready for this decision. And when it came through, there was an effort very quickly to reverse course. Now, our last one is McCulloch v. Maryland. And this background is really interesting. So, this is all tied up in this idea of the second bank of the United States. Maryland didn't like the Federal Bank of the US, and so it tried to weaken it by imposing a tax on all banknotes that were not chartered in Maryland. James McCulloch, who was a cashier at a Baltimore branch of the Bank of the United States, refused to pay the tax, and the suit came out of that. So the questions were twofold. One, whether Congress had the constitutional authority to establish a national bank in the first place, and two, whether a state could tax a federal institution. John Marshall ruled in two cases, both for the federal government. One, he ruled that Congress had the power to create a national bank under what is called the Necessary and Proper Clause. And two, that Maryland could not tax it because, quote, the power to tax involves the power to destroy. The case established two key principles. One, implied powers, that Congress is allowed to take actions that are not explicitly listed in the Constitution if they are necessary to carry out its duties. And two, federal supremacy, that the states cannot interfere with valid federal actions. Now, this era all came to an end with really one conclusion, and that is that through the federal judiciary and under the auspices of John Marshall, federal power increased dramatically at the expense of the states. And this back and forth, however, isn't really over. Many will argue it's not over even still today, but it certainly isn't going to get through its biggest challenge until 1860, 1861, with the declaration of the American Civil War. That is a story for another day.